In rising speed to my amendment 186A, I hope noble lords will forgive me if I don't speak in detail to the many other amendments gathered together in this group, correctly branded miscellaneous by those who compile our lists for us. Many of them are minor and technical, especially the government amendments. I will just say, of course, that that's not true of all of them, and amendment number 253 in the name of the noble Lord Clement Jones, is a substantial amendment relating to regulatory cooperation, while Amendment 275A is also of some interest relating to reports that Ofcom is being asked to produce. This in the name of the noble Baroness Lady Finlay of Llandaff, in relation to technological developments. Nor is Amendment 191A lacking in importance and substance, though for those of us, and I hope I'll be forgiven for saying this, not in a snarky sort of way, but for those of us who are worried about the enormous powers being given to Ofcom as a result of this bill, the idea that they should be required by statute to give guidance to coroners who are part of the courts system seems to me strange and worth examining more closely. There might be a more seemly way of achieving the effect that the noble Baroness Lady Kidron understandably wants to achieve. But I'll turn, if I may, to my own amendment, which is 186A, which ought to be, I hope, relatively straightforward. It concerns the terms of service of a contract with a Category 1 service provider, and it is intended to improve the rights that consumers or users of that service have. Now, it is the case that the government wants users of those services to have the ability to enforce their rights under contract against these service providers, and that is set out at Clause 65 of the bill. And that is, of course, entirely welcome. But it is well known that bringing claims in contract can be an expensive and onerous business, in particular when the service is provided, as I have pointed out in the past, on the one-sided terms of the service provider, often, of course, drafted under the legal system of a foreign jurisdiction. Now, Parliament recognised this difficulty when it enacted the Consumer Rights Act in 2015, and its purpose was to make it easier for consumers to deal fairly with traders and to get redress when they are treated unfairly. Category 1 providers such as Twitter and Facebook, however, are not governed by the Consumer Rights Act. In the language of the Act, they do not supply digital content for a price paid by the consumer, which is a requirement of the Act. So the purpose of Clause 65 is therefore only partially achieved in the bill as it stands. A key element in enforcing consumers' rights is missing. Now, the European Union, to its credit, rectified this oversight in its directive modernising consumer law in 2019. It provides that a consumer who receives content or a service in return for providing their personal data should be in the same position as the consumer who pays a price, and the same consumer protections apply to both. The effect of my amendment is that we would follow suit. And if we are serious about both protecting and empowering users, that is what we should do, and do away with the arbitrary fiction that Category 1 users are not consumers deserving of protection simply because they don't pay a monetary price. Now, I have heard it said that bringing up this matter on report, when it should have been, I admit, brought up in committee, if I'd thought about it, it should have been brought up in committee, that it is a little bit too late, perhaps, for the bill team and the Minister to absorb this proposal. But I don't fully accept that, since third reading of this bill has been set for the 4th of September, which gives the government very ample time over the summer to get all its ducks lined up in a row. And I would have thought this amendment would command support on all sides of the House and from all participants who have, all noble lords who have participated in this bill so far. And so I'm hoping, I haven't had any indication from my noble friend the Minister whether he's going to accept this amendment or not, but I'm hoping that he would feel it was a relatively straightforward thing to do, that it was entirely in line with his purpose, and that it was something that would strengthen the bill considerably. I beg to move.
Amendment proposed, insert the new clause.